All right, good afternoon, everyone. I'm Judge Steinlage. This is Division 2 of the Cook County Superior Court. We're on the record in State of Arizona versus Francis Cruz Mendoza-Keel. This is the time set for trial in CR 2025-00513. And I'll just turn it over to the parties to put your appearances on the record first.
Good afternoon, Your Honor. Kevin Kent, along with Javen Arocho, Jeff Willis, case agent for the state.
All right, thank you.
And Daniel Hartmann-Strawn appearing with Mr. Francis Cruz Mendoza-Keel, who appears present in custody, and Mr. Robert Estrada, who's appearing as our paralegal.
All right, thank you. And did Mr. Estrada, did you want the court to introduce him, or did you want to introduce him at the same time that you introduce your client?
I think I'll just introduce us all together, Your Honor.
Okay, very well. I'll give you that opportunity. I did want to ask you, Mr. Hartmann-Strawn, in one of the emails I sent last night, I wanted to know whether or not you wanted to be identified to the jury pool as a deputy public defender or just counsel for the defendant. What's your preference, or do you have one?
It doesn't really make a difference to me, Your Honor. Deputy public defender is fine.
Okay, very well then. The parties, just to give everybody an update, I think we had 36 jurors appear. They're working, well, I've ordered that closed, and we're just waiting to find out, get the randomized list of those jurors for what order they'll get called into the box. So that's all we're waiting on right now. I appreciate everybody responding to my emails with the preliminary instructions. Up to this point, I think we're kind of ahead of the game on that. So at this point, I've already gotten those printed out. Each party should have gotten 2 copies of those. I have the original copy here. Just for the record, does everyone approve of those preliminary instructions?
Yeah, the state does approve. One just quick thing to supplement the record. I just want the record to reflect the defendant is present in custody, but he's present in custody, but he is wearing street clothes or a suit, not a prison jumpsuit.
All right, thank you. And regarding the instructions, Mr. Hartmann-Strawn?
Nothing to add, Your Honor.
Okay, very well. In that case, we've addressed that. So when we're ready for the instructions, hopefully this afternoon, we're ready to go. And Mary informed me that the parties didn't have anything that you needed to put on the record. You were ready to get started as soon as the jurors are ready. Is that right?
Yes, Your Honor.
Yes, Your Honor.
All right. In that case, we can go off the record, and hopefully we'll have that randomized list soon, and we will get started, get the jury up here, and get started with voir dire as soon as they're ready. Is that the list? Wow, that was very timely. Okay. I know that sometimes there's some prep in terms of organizing based on the list to be ready for voir dire. Do the parties just want a few minutes and just let me know when you're ready to go?
Stay would ask for about 5 minutes.
Okay.
That should be fine, Your Honor.
Thank you. Please be seated. Good afternoon, ladies and gentlemen. I'm Judge Steinlage, and welcome to Division 2 of the Cook County Superior Court here on St. Patrick's Day. So welcome, everyone. We're here today to hear the case of State of Arizona versus Francis Cruz Mendoza-Keel, case number CR 2025-00513. The court notes the presence of the defendant and his attorney, Daniel Hartmann-Strawn, and the attorneys for the state, Javen Arocho and Kevin Kent. Is the prosecution ready to proceed?
Yes, we are, Your Honor.
And is the defense ready to proceed?
Yes, Your Honor.
Will all prospective jurors now please stand and be sworn?
Do you and each of you solemnly swear or affirm that you will truthfully answer all the questions asked by the court and counsel touching upon your qualifications to serve as a trial juror in this case now on trial?
All right, and everyone may please be seated. Ladies and gentlemen, we're now going to begin the jury selection process. At this time, the clerk will call the names of all 9 prospective jurors.
Number 1 is Raylan Gilder. Number 2 is Gary Gunderson. Number 3 is Lori Scandura. Number 4 is Thomas Perkins. Number 5 is Renee Fawcett. Number 6 is Amy Stone. Number 7 is Rain Melly Tilleria. Number 8 is Aubrey Lee. And number 9 is Amy DeJolie.
All right, and welcome everyone. Ladies and gentlemen, it's now necessary for me and the lawyers to ask you some questions to find out if you have any knowledge about this case or about any of the persons who might be involved in it, to find out if you have any preconceived opinions about the case which you might find difficult to lay aside, and to find out if you've had any personal or family experiences that might cause you to identify yourself with either of the parties. These questions are not designed to pry unnecessarily into your personal lives or affairs. We ask them only to assure that we select a fair and impartial jury. Most of the questions that you're going to be asked are yes or no questions. If your answer to a question asked of the whole panel is no, you don't need to do anything. If your answer to a question is yes, please raise your hand and then I'll call on you and ask some additional questions. Based on that conversation, you may remain on the panel or you may be excused from the panel. If I excuse you as a juror, you should go back to the jury assembly room where you began your day and collect any materials that you might have down there. Those jurors who have not yet been called should not answer out loud any of the questions that I'm asking at this time, but please do listen closely to all the questions and make notes of any yes answers that you happen to have. Some of you will be called to join the jury panel. When that happens, the first thing that you'll be asked is, do you have any yes answers to any of the questions that were previously asked of the panel? If you'd like to have a notepad to keep track of any yes answers you have and you don't have one, please raise your hand and the bailiff can assist you with getting you one. There are a few rules that I ask of each of you to follow during this process. First, there are no right answers, and there are no wrong answers to any of these questions. Please answer truthfully and not in the way to think that you are supposed to answer. We're asking these questions to determine your true beliefs on certain aspects of this case. Please do not hesitate to tell us your honest views on the matters that we're going to discuss. It ensures that we get a fair and impartial jury. Second, please speak loudly and clearly. Our court reporter here must take down every word that is spoken here so that it would make her job much easier if you speak loudly and clearly. Third, when we do have any conversations about any of the yes answers that you might have, I'll call on you by name. If I neglect to do that, please remind me and state your name for the record at that time. Again, this makes the court reporter's job easier down the road and makes for a better record of the proceedings. Finally, if at any time a question posed touches on things that are very personal or private to you, or if for any reason you think you'd like to have more confidentiality in your answer, you can just ask to approach, and the court will grant that request, and the parties will approach with you at the bench, or we may have a brief recess, but we'll discuss the matter at the bench or outside the hearing of the other jurors to provide you with the confidentiality that you deserve. Before I ask Before we ask the questions that we have for you, there are certain basic minimum qualifications that you must meet to sit on the panel. So please listen to these, and if there's any one qualification that you might not meet. First, you must be 18 years of age or older. Secondly, you must be a citizen of the United States. Third, you must not have a felony conviction, or if you have had a felony conviction, you must have had your rights restored. And fourth, you must be mentally competent. Is there anyone who does not meet any of these qualifications? And if so, please raise your hand. And there are no hands for the record. In addition, you all must reside in Coconino County within the jurisdictional boundaries of this court. Is there anyone here who does not live in Coconino County? And again, for the record, there are no hands. So before we go any further, I want to introduce the staff for this division. Our bailiff during the trial is going to be Ernie Fonseca. You've all met him already. The bailiff assists us in getting into the courtroom on time and helps with many other tasks. He may leave from time to time during the trial to perform some of those other duties. This division's judicial assistant, my personal judicial assistant, is Mary Moore. Her office is just on the other side of the door there. You may see her coming in and out from time to time. If you need anything during the trial, either the bailiff or my judicial assistant would be more than happy to assist you. Our deputy clerk for this trial is Ashley Sherman. She's seated here just to my right. Among other things, she keeps the official record of the proceedings and handles all of the exhibits and swears in all the witnesses and jurors. Seated in front of me here to my left is our court reporter, Michelle Lagys. She takes down everything that's said in court so that we can have a word-for-word record if necessary for future proceedings. Again, my name is Josh Steinlage. I'm the judge here in Division 2 of the Coconino County Superior Court. Our phone number here in this division is 928-679-7575. I'll provide that phone number again to everyone during the preliminary instructions if you are chosen as a juror ultimately. But at this time, does anybody here know me or anyone that's on my staff? And there are no hands for the record. I'll now introduce the persons that are seated at the respective council tables. The state is represented here today by Javen Arocho and Kevin Kent. Did any of you know either Mr. Kent or Mr. Arocho or anyone associated with the county attorney's office? And just for the record, there's no answer. And would either Mr. Arocho or Mr. Kent like to introduce the person that's seated with you there?
Thank you, Your Honor. Seated to our right is Deputy Jeff Willis. He's a sheriff's deputy with the Coconino County Sheriff's Office. He's our case agent on this case.
And do any of our prospective jurors know Deputy Willis or anyone else associated with the Coconino County Sheriff's Office? And just for the record, there are no hands. The defendant today is represented by Counselor Daniel Hartman Strawn here today. And Mr. Strawn, do any of you know Mr. Strawn or anyone who works with him? And there are no answers for the record. And Mr. Strawn, would you like to introduce your client today?
Absolutely. This is Mr. Mendoza-Keel. He's the defendant in this trial. And then I'm also joined here by Robert Estrada, who is a paralegal in my office and will be assisting me during the course of this trial.
All right, thank you. The names, or I should back up just a moment. And in this case, the defendant is charged with committing 2 counts of aggravated assault on a peace officer, 1 count of disorderly conduct, and 1 count of assault. Those offenses are alleged to have occurred on April 22nd of 2025 here within Coconino County. The name of the alleged victims in the case are Colin Knight, Jeff Willis, and Howard Leventhal. The defendant has pleaded not guilty to these charges. As will be discussed in more depth later during jury selection, a charge is not evidence of a crime, and the defendant is presumed by law to be innocent. Nonetheless, is there anyone on the panel just hearing the allegations themselves has concern about their ability to be fair and impartial. And just for the record, there are no hands. Has anyone on the panel ever heard, seen, or read anything about this case? Or have any of you ever heard anyone else express any opinions about this case? And there are no hands for the record. And if you'll just look around a bit, has anyone there on the panel spoken to any other prospective jurors about the case here today? And there are no hands. So I'm now going to read a list of witnesses who may be called to testify during the trial. Not all of these persons will necessarily testify, but any of them might, or their names might be mentioned. Deputy David Garcia Barragan, Deputy Colin Knight, Deputy Jeff Willis, Howard Leventhal, and Patrick Pavoloni. Please raise your hand if you know or you think you might know any of these people. And there are no hands for the record. And ladies and gentlemen, we know that jury service can be an inconvenience to you, as you all have matters of importance, and jury service interferes with those things. And you know how important it is to our community that persons such as yourselves are willing to serve on juries. We know that you recognize the importance of jury service. Our system works because people like you are willing to come to court, perform jury service, and decide cases like this one. Jury duty is one of the most important civic duties that citizens of this country are called upon to perform. I know that each of you will take this duty, not take this duty lightly. I'm going to tell you just briefly about the schedule of the trial in case you don't recall from the Survey Monkey that you completed. This case is only expected to last through this coming Thursday. Today, we anticipate that we'll have trial and work on the case until about 5 o'clock. And then we anticipate on Wednesday, tomorrow, the 18th, and Thursday, the 19th, the jury's going to be here and working with us from 9 o'clock until 5 o'clock each day. Is there anything about the anticipated length or daily schedule of the trial that presents a problem, whether it be personal, business, or health related, that is significant enough that you feel the need to ask to be excused from service on this jury? All right, we've got Ms. Lee there at number 8. If we could hand her the microphone, Ernie. Yes, Ms. Lee.
Hi. My sister is pregnant, and we just found out today that it turned high risk, and she's going to be induced emergency tomorrow morning. And not only do I want to be there to support her through that, since the baby's life is at risk at this point, I feel as if I can't be fully here. I don't want to be distracted during a trial. I don't want to be in my own personal head thinking about stuff. Yeah, I just want to stay fair.
Right. And I appreciate your candor in letting us know about that going on in your personal life. Is that going to be happening here in Flagstaff, or are you going to be traveling for that?
It's here.
Okay. Thank you. Did anybody else have any concerns with the schedule? It looks like we have Ms. Stone, number 6.
Hello, thank you. I'm a school nurse in a Flagstaff Unified School District. I care for a number of high-risk children. There are no other substitute nurses to be able to assist with those children, and so it's a population of about 400 kids. While honored to be here, and it's an exciting experience, I feel that my duty is also to be in my job.
All right, thank you. And any other hands on that particular matter on the schedule? There are not. Could I have counsel both approach? And I'm going to warn you, I have this tool up here that I can put this screeching white noise above your heads, and I'm about to do that. So just prepare you for it. I usually forget. All right, just, we've had 2 jurors that have asked to be excused based on hardships. Ms. Lee has this situation with her daughter and her sister being induced into labor tomorrow. I have to say I share her concerns that if her daughter's or her sister's in the middle of that tomorrow, she's unlikely to be able to maintain focus. Does everyone agree?
Yeah, state agrees to strike for hardship and cause.
And this is Daniel Harbenstrong for the defense, and we would agree to strike her for cause.
Hard charge.
I'm sorry, yes, hard charge, yes.
All right, and then as to Ms. Stone, our prospective juror number 6, she's expressed that she is a nurse for Flagstaff Unified School District and the only nurse at her particular school with no alternate folks to come in her place. The standard for excusing a person on the basis of excusing them from work is that it would substantially and materially affect the public interest or welfare in an adverse manner to keep them here. You just never know, I guess, what's going to happen at a school on a given day. What are your respective positions?
This state would strike for hardship.
And the defense would also agree to strike for hardship.
All right, I will excuse each of them and we'll replace them and I'll pick up where I've left off.
Thank you.
Thank you. All right, and hopefully the white noise isn't too terribly unpleasant for all of you. At this time, Ms. Lee, good luck to your sister. I hope everything works out, but we are going to excuse you at this time. Before you go, though, and we're going to excuse you also, Ms. Stone. Before each of you go, I just want to thank each of you for being here today and for doing the Survey Monkey before you got here. Well, I realize that alone is a lot of work and that we ask a lot of people just to get to the point where we are right now. So thank you for showing up. Thank you for doing the Survey Monkey, and you're both excused at this time based upon the hardships that each of you have. All right, at this time, I'm going to have the clerk call the next 2 prospective jurors.
The new number 8 will now be Kimberly Linden. The new number 6 will now be Sandra Curie.
You skip some. Oh, no, she's 9. Okay.
All right, and welcome to both Ms. Curry and Ms. Linden. Up to this point, have you had any yes answers to any of the questions that I've asked up to this point? All right, just for the record, both prospective jurors are shaking their heads no. So I appreciate that. Please understand that the law provides a juror can be excused only if his or her absence from work would substantially and materially affect the public interest or welfare in an adverse manner, or if service as a juror would impose an undue or extreme physical or financial hardship on you or someone else under your care. The jury trial fund may make some monies available to pay full or partial earnings to jurors who receive less than full compensation. The amount of such earnings would be at least $40, but not more than $300 per day per juror. If you are selected as a juror in this case, you'll need to provide the following information about your normal daily earnings and how much you're actually earning while on jury service. I think I said the following information. The jury commissioner or a member of his or her staff will meet with the jurors who are selected for the juror to provide the necessary claim forms and explain how to fill out the forms and itemize the supporting documentation that's required. Jurors will be required to provide their social security number in order to receive full payment from the fund. Do any of you believe at this point that you should be excused for any of these reasons that I've gone over up to this point? And there are no hands. Is there anything that would make it difficult for you to hear or see evidence if you were selected as a juror? And there are no hands. If at any point during the trial you cannot hear or see evidence, you can also raise your hand and let me or any member of my staff know. Now, at this time, I'm going to ask you to awkwardly look around and take a good look at each other. And I'll ask if any of you know any of the other members on the jury panel. All right, we got some hands. I'm always amazed. I guess it just shows us how small Flagstaff is and how small Coconino County is when we get to that question. Let's start in the back with number 5, Ms. Fawcett. And if we could hand her the microphone. And who do you know, Ms. Fawcett?
I know Miss Lloyd. We call her Miss Lloyd. We work together in a school, and so.
Okay, you currently work together?
Well, not currently, but we have in the past.
Previously?
Yes.
Okay.
Mhm.
And would your prior work relationship with Ms. Scandura, would that affect your ability to be fair and impartial in the trial as far as you can see it?
No,
Would your prior relationship with her cause you to put undue, greater weight on any of her opinions as you were deliberating or anything like that, as far as you know?
no.
All right, thank you. I appreciate your candor. And let's pass it over to Mr. Perkins, number 4. And Mr. Perkins, who do you know?
I also know Mrs. Skandura here.
Okay, thank you. Also from working at a school previously, or how do you know her?
No, I was a close friend with her son in high school.
Okay.
And, we're still friends today, so I've known her for quite some time.
All right, so the mother of a good friend?
Yes, sir.
All right, with that existing relationship, an ongoing relationship, would that affect your ability to be fair and impartial in your duties as a juror here?
I don't believe so.
All right. Do you regularly socialize with Ms. Scandura, or is it primarily limited to time with her son?
Primarily with her son.
All right. And thank you for that. Let's pass the microphone over to Ms. Scandura, our most popular juror this afternoon.
I could break out in song, but.
And Ms. Scandura, do you know both Mr. Perkins and Ms. Fawcett then?
Yes.
All right. Do you, anything based upon those, the previous relationship that you had with Ms. Fawcett at work and the ongoing relationship that you have with Mr. Perkins as a friend of your son, would that affect your ability to be fair and impartial here in any way that you could see?
My friendships will not make me, I will be fair and impartial.
All right. Thank you very much. We can go ahead and pass the microphone back down to Ernie at this time. And at this time, I get to thank all of you for everything that you've done up to this point. And this includes everyone that's in the courtroom, frankly, as a prospective juror. I want to thank everybody for completing the Survey Monkey. The Survey Monkey is something that we started during COVID so that we could continue to do business and do the work of the citizens here in the courts, but trying to do it in a way that protected the safety of people as much as we possibly could. So we started doing those surveys to get information that we normally did all in the courtroom before COVID. And we would have so many questions that we asked everybody during jury selection to get to the point we're already at. It worked so well, and we got so much information from it, and the attorneys liked it as well, that we stuck with it. And we've continued to do it because it's one of the good things that came out of that horrible time, and it's helped us get better information about everybody before we even get to this point in the trial. So I wanted to thank everybody for that, because you have no idea how much we've jumped forward in terms of time here in the courtroom by each of you completing that survey before we're here today. With that, I'm going to be turning it over to the attorneys to do their respective voir dire and ask questions that they have as follow-up for each of you based upon that Survey Monkey response that you already did. So at this time, I don't know if Mr. Arocho or Mr. Kent, which of you were going to take the lead on jury selection. So it looks like it's going to be Mr. Kent. If you'll go ahead and come forward. I want to invite the attorneys. We have the podium here to the side. If anybody wants to use that, roll it out and use it before we have witnesses tomorrow. We'll put it over here so that it's not in anybody's way. But everybody, I think you all know in my courtroom, when it's your turn, use the space how you choose. And if you want to move things around, just do it. Okay? And I'll turn it over to you, Mr. Kent. You may proceed.
Thank you, Your Honor. Good afternoon. Again, my name is Kevin Kent. I'm the attorney for the state, or one of them, along with Javen Arocho. One question I wanted to ask for the panel, and for anyone who might be on the panel, is because we've received some responses about it in the SurveyMonkey, is previous experience yourself or a close family member or friend with assault. I think it's possible some people might think of a certain kind of assault when they're giving their answers to questions like that, or their responses. This case is about a physical assault, a fight type assault, not sexual assault, children, anything of that nature. So I wanted to ask the panel if, based on this information and any previous responses anyone has given with their feelings toward being a juror on a case involving assault, whether they have any concerns or problems they foresee. Does anyone have any problems? And I see.
I mentioned it in my SurveyMonkey.
Just wait for the microphone.
And just for the record, that's Ms. Fausted, prospective juror number 5.
I think I did mention in the SurveyMonkey that I do have a certain amount of aversion to violence. Like I'm the person that covers their eyes during R-rated movies if there's anything violent. I mean, I think I can be all right. I mean, it's sort of a physical reaction.
Okay. And knowing that this case is about an assault that's, like I said, a kind of a fight. There's no guns, weapons. I think it's fair to characterize as no gore.
Okay.
Knowing that, do you have any concerns about being a juror?
No.
Okay.
All right.
I think I saw someone else. Number 1, your name is Ms. Gilder? Yes.
Ms. Gilder, let's give Ms. Gilder the microphone if we could.
Okay.
And Ms. Gilder, you were asking to speak with us privately?
Yes.
All right, let's just pause on that and we'll come back to that momentarily, okay? But thank you for letting us know and we'll get back to you.
And I think number 3, Ms. Skandura, you had a response?
I've been a volunteer in the county jail in the past, like 2012-ish. And I would go in on behalf of my church and conduct a Bible study. Most recently, I'm a volunteer with Kairos Outside Prison Ministry International. And one of the programs supports women on the outside who have been incarcerated or have a loved one incarcerated. And I do feel that I can be impartial in this situation.
You feel that you cannot be impartial?
I feel that I can be.
You can, okay.
I didn't want you to find out later and then ask me why I didn't say anything.
I appreciate you sharing all that. So I guess it sounds like it's fair to characterize you have just some previous experience with dealing with people in the criminal justice system. Is that what you're saying? But you feel that doing that through your church and knowing what you know about this trial, you feel like you can be fair and impartial juror on this trial?
Yes, sir.
Thank you. Oh, I'm sorry. And while we're speaking, I did have a question for you, Ms. Skandura. Do you know Amanda Delano?
Yes, I do.
And how do you know her?
My husband and her father are good friends. I've been a part of social events with her. Maybe I see her 3 times a year.
Okay, and just for the record, Ms. Delano is a staff worker in the county attorney's office. So knowing your husband, being friends with her father and seeing her a couple times a year, knowing that she works in our office, do you have any concerns about maintaining impartiality as a juror in this case based on that relationship?
I have no concerns. I can be impartial.
Thank you. I have a question for Mr. Perkins, number 4. Mr. Perkins, you said something in your response that you felt like you wouldn't be able to sit and render judgment. Do you recall saying that?
Yes, I seem to recall saying something to the effect of being uncertain to render judgment with imperfect information.
So you would want to hear information or evidence before you were asked to make a judgment. Is that what you're saying?
Yes, effectively.
Okay. So the way this works is the state presents its evidence, testimony, exhibits, things of that nature. And the state presents the evidence that it feels is necessary to prove charges beyond a reasonable doubt. The state sometimes may not present evidence that you have or would have liked to see, but the question I'm getting at is if based on the evidence that is presented, you believe the state has proven allegations beyond a reasonable doubt, would you have a problem returning a verdict of guilty in those circumstances?
No, I would not.
And just to drill down a little further about rendering judgment, because I think some people, I'm not sure if it's a religious thing or a philosophical thing, some people just feel like for whatever reason they can't sit in judgment of another person, another human being. Is that type of concern a concern you have, or just more about having information?
I suppose I would characterize it as a desire for sufficient information.
Sure. But my question is, you don't, just as a global statement, feel that you're someone that I just can't sit in judgment of another person. That's not your position?
No, it is not.
Okay. I think you said something about you have family members in law enforcement. Is that correct?
I do, yes.
So the court's going to read instructions, and part of those instructions are going to be that you consider the testimony of every witness, that you use the same test to determine the credibility of every witness, use the same test for every witness, whether they're a law enforcement or non-law enforcement, and that you can't put greater weight on someone's testimony just because of the fact that they are law enforcement. Would you have any trouble following the court's instructions in this case?
I would have no trouble following them intentionally, no. The reason why I stated that is because I cannot guarantee that there would be no sort of unconscious bias that may be present. I felt it was something that you should be informed of.
Thank you, and I do appreciate your candor. So I think it's fair to say everyone has unconscious biases one way or another, and I think it's noble that you recognize yours may be towards law enforcement because of your family relationship. But do you think that this potential in your mind for unconscious bias renders you someone who is not able to sit as an impartial juror in this case, which does involve allegations of assault on law enforcement members?
I do not.
Okay, and do you mind expounding on that at all?
I do not think that it will compromise my ability to be impartial insofar as a person can be.
Okay, thank you. Understood. Thank you. I don't have any further questions for you. Can we pass the microphone to Juror 8, Ms. Lee? I think you, Miss Lee, correct?
Linden is my last name. So maybe
Uh-oh.
the second half of my name might be.
Lee was the excused,
Oh, excuse me. I'm sorry.
Mr. Kent.
I didn't update my sheet. Never mind. Oh, one moment, Nana. What am I missing? Okay. I guess I was live. Sorry, actually, I do have a question for you, Ms. Linden. I'm sorry about that. You have friends friends or family in law enforcement, is that correct?
Yes.
And is it friends or family? Or
Friends.
Okay. And what agencies do they work for?
He was a police officer for the NAU PD. I mean, for NAU PD and for Flagstaff PD before that.
This is one friend.
Yes, and just his family, his wife, his children.
You're friends with the whole family?
Yes.
Or they're all law enforcement?
I'm sorry. I'm just know his wife and children as well, not just him.
I understand. And having a friend who's still law enforcement or former law enforcement?
He is former. He retired last year, I think.
Okay. Having a close family friend who's law enforcement, do you feel like that would be a problem for you maintaining impartiality as a juror in this case?
I don't think so. I just want to be fair. And I feel like just in my career, I've been dependent on law enforcement or worked with law enforcement in the realm, not directly with them, but I just feel like our family's very lean toward supporting law enforcement because of, our experiences.
I absolutely understand that. So are you feel like a little bit like Mr. Perkins answered earlier?
I do, actually. What he said resonated because I feel like I would definitely try, but I also, have had a lot of life experiences around law enforcement. In my career, I was a foster care caseworker and a teacher for low-income schools. So we we relied on law enforcement to help, and I worry that I would see their side. But if I'm put on a jury, I will do all I can. I just worry that, I don't want to lean toward one side or another.
So would it be fair to characterize your answer as you're going to try your best?
Yes.
This might sound harsh, but
no.
If you were getting on a plane and the pilot said, I'm going to try my best to fly
I know.
this plane, do you feel like that?
I would say someone on here's not real. Get thrown up. I understand. I know it's difficult.
No,
it's difficult to say too.
I very much appreciate your candor. I don't have any further questions for you. Okay. Thank you. I don't have any further questions for the panel at this time.
All right, thank you. At this time, let's step into chambers. If we could have Melissa come into chambers, and we'll call Ms. Gilder and address her issue. And then we'll be back as quickly as we can. I apologize for this. I'm going to do that. All right, we're back in the courtroom on the record, and I apologize for leaving everybody in the white noise that long. It's a little obnoxious. I apologize. At this time, the court is going to excuse you from jury service. Ms. Gildner, I appreciate you being here today and sharing with us. I'm also going to excuse you, Ms. Linden, juror number 8. And I also thank you for your candor in your answers here today. We appreciate that very much. And at this time, the clerk will call our next 2 prospective jurors.
The new number 1 will now be Adriana Marshall. And the new number 8 will now be Ryan Skillman.
All right, thank you, and welcome, Ms. Marshall and Mr. Skillman. Up to this point, were just focusing on the questions that I asked, did either of you have any yes answers to any of the questions that I asked? And both are shaking their heads no. So with that, I'm going to turn it back over to Mr. Kent and allow Mr. Kent to proceed with the state's voir dire. Go ahead.
Thank you, Honor.
And if counsel, make sure microphone's back on. Sounds good.
Ms. Marshall, welcome. Looks like you're pregnant. Is it 33 weeks? Is that? Okay. Do you have any concerns? Oh, thank you. Physically sitting here, potentially sitting in that chair for 1 to 3 days?
No, I just would appreciate lots of restroom breaks for sure.
We can accommodate that.
Okay.
And I think you said you have a brother who worked in law enforcement.
Probably like 20. Well, I guess he technically still does. I'm not sure what exactly. He was a police in Tucson, maybe like 20 years ago, a long time ago. And I think now he does stuff for Homeland Security.
Okay. Are you no longer close with him, or not sure what he's working on?
I asked him like what he does, and he doesn't give me specifics, so I just couldn't tell you. We're not super close. He lives in New Mexico right now, so.
And based on his prior, possibly present work in law enforcement, does that give you any concerns about being fair and impartial in this case?
No.
Okay. Thank you. I don't have any other questions for you. What was the other question I was going to ask you? Okay, Ms. Tilleria, is that correct, or is there a hyphenated last name?
You can just call me Miss Mello.
Ms. Mello, excuse me. Welcome. You noticed a few things about family being involved in the criminal justice system, is that correct?
I grew up with a lot of criminals in my family.
Okay. And just growing up with people who were either criminals or they were caught presumably involved in the criminal justice system, does that give you any pause about sitting here and being a fair and impartial juror?
No.
And I think you said you or possibly other people in your family had been victims of crime at one point or another. Anything about that gives you pause?
No, I appreciate being here and seeing the system at work.
Thank you. I don't have any further questions.
All right, thank you. At this time, Mr. Hartman-Strawn, you may conduct your voir dire.
Well, good afternoon, everyone. Let me just get through the folks we already excused here. Could you please pass the microphone to Ms. Fawcett? So you mentioned when you were speaking with Mr. Kent from the state, and I really appreciate you saying this, but you have a strong aversion to violence, which I totally understand. Would that strong aversion to violence cause you to either prejudge or more harshly judge someone who's accused of committing physical violence?
I don't think so. You know, and it seems as though the case is not as, you know, I knew nothing about the case, so I did not know how violent it was. But if it's, you know, just fighting or something, I think I can be impartial.
Okay, wonderful. Thank you so much. You can pass the microphone back. Let's see. Can you pass it to Mr. Perkins? I also really appreciated your sort of, you know, philosophical approach to sort of, you know, standing in judgment of people, how you kind of approach that. You know, the standard in criminal cases is the state has to prove beyond a reasonable doubt that the defendant is guilty of what they're charged with, or that they haven't presented certain defenses beyond a reasonable doubt, or they have to prove beyond a reasonable doubt, basically, that certain defenses do not exist. Sorry for all the double negatives there. Are you satisfied with that standard? Even I know you have your own personal standards that you might judge things by, but in this context, are you satisfied by that standard?
Yes, I believe that's a sensible standard.
Okay, wonderful, wonderful. And then just one other question, you know, just your own, you know, biases. It sounds like you have law enforcement in your family, and then also your kind of own, you even call it bias, but your own sort of approach to judgment. Would you be able to just set any of those things aside in the context of this courtroom, in the context of sitting on this jury, and just follow the instructions given to you by the judge?
As I previously stated, I will absolutely be able to do that intentionally. My only concern would be the infiltration of unconscious bias that may arise that is beyond my control. I don't believe it would be a major contributing factor, but I wanted to be candid about it nonetheless.
No, I really appreciate that. And sorry, actually, I guess I have one more follow-up just based on that good answer. Do you think that, you know, in essence, understanding that you have this potential bias, and I think it's really impressive and introspective of you to understand that, and brave of you to speak about it, do you think you're going to, in fact, because you recognize you might have that, be able to sort of head that off, or at least try to make sure you're really scrupulously staying within the lanes that the judge is going to give you here in the instructions?
It will certainly give me the opportunity to do that, and I would certainly make the attempt to do so, yes.
Wonderful. You can pass that microphone back. Thank you. Let's see. Now I'm actually going to have some group questions. And this is just like as the judge did with his initial questions. If you feel that your answer is yes, or if you kind of want to elaborate on an answer or anything like that, raise your hand. We'll pass you the mic and we'll talk about it. You can just leave your hand down if you feel like you don't, you know, identify with that question. Please raise your hand if you've ever been confronted for something you felt like you didn't do. Mr. Skillman, do you mind taking the microphone? You know, and I'm not going to ask you to get into what you're accused of, but, you know, when that person or that institution or whatever it might have been brought to your attention the thing that you were accused of, that you might have been charged with, whatever the case might be, was your response first? Do you have questions about it? Were you confused at all?
Sure. I think it's a pretty common experience, but context, what was I accused of doing? How could I have done it? Was it possible I did it and wasn't aware of it? That type of stuff, for sure.
Did you feel like you wanted to have the opportunity to be able to ask questions, to have a dialogue about what you're being accused of?
Yeah, 100%.
Do you feel like it's important that that sort of dialogue takes place before people jump to conclusions or action?
I think that's the expectation we're all built to have, yeah.
Perfect. in that situation, and again, without asking you to go into any detail, but did you end up having to stand up for yourself to push back against what was being brought against you?
Sure. Again, I think we've all had to do that. I don't think it's an uncommon thing, but yeah, absolutely.
All right, wonderful. And then I'll open you can pass the mic back. Thank you so much, sir. I'll open this up again to the group. Has anyone ever had experience with law enforcement, even if it ended fine, but where at least initially you were confused, you were anxious, you found it frightening or stressful? Yeah, I'm so sorry. Let's see, is that, I'm getting all the names mixed up here.
It's Ms.
Mello, right? Can you pass the mic to Ms. Mello? Sorry, Your Honor. Do you mind telling us about that, Ms. Mello?
Yeah. As a child, my dad was arrested multiple times, and a lot of the time, because of his prior arrests, it was a lot more aggressive than it needed to be. Even when he wasn't trying to fight back, there's a lot of aggression shown. So, yeah.
And do you feel like sometimes, I'm kind of reading between the lines, so correct me if I'm getting this wrong, but do you feel like sort of there's almost an assumed response of we're going to take this person in, we're going to get physical with them, something like that?
Yeah, and especially in front of children and when there was no arguments happening. Yeah.
Do you feel like in at least some of those instances there could have been maybe more discussion between arresting officers and stuff and the person being arrested before they jumped to handcuffs?
Yes.
Thank you so much. I really appreciate that. And I don't have any further questions, Your Honor.
All right, thank you. Could I have counsel approach, please? And does the state pass the panel at this time?
The state does, Your Honor. Kevin Kent for the state does pass.
And this is Daniel Hartman-Strawn for the defense, and we pass.
All right, thank you. All right, ladies and gentlemen, each of you has been found to be a fair, impartial, and qualified potential juror on this case. At this time, the clerk will now read the names of the selected jurors to hear this case.
Adriana Marshall, Gary Gunderson, Lori Scandalera, Thomas Perkins, Renee Fawcett, Sandra Curry, Rain Mello-Tiria, Ryan Skillman, and Amy DeJolie.
All right. For those of you that were not selected as jurors, I want to thank each of you very much for your participation here today and your willingness to serve on the jury. At this time, you're all excused. Again, thank you so much for doing the SurveyMonkey, showing up in the first place here today. We appreciate all of you and you making this process possible. So thank you very much. You are all excused. All right, thank you, Ernie. At this time, I'm going to have the jury all please stand and be sworn.
Do you and each of you solemnly swear that you will give careful attention to the proceedings, abide by the court's instructions, and render a verdict in ordinance with the law and evidence presented to you, so help you God?
All right, thank you. Please be seated. At this time, I think it would be appropriate to just take a brief recess since we've already got our jury selected. Give everybody a chance to stretch your legs, use the restroom, things of that nature. When we come back, I'm going to read the charges to the jury, and then I'm going to read what's called the preliminary instructions, which is all the instructions you get and have a copy of throughout the trial itself. So we'll come back and be ready for that here just momentarily. So at this time, everyone's excused, and we'll see you back maybe in 5-10 minutes. 10 minutes. I think we'll be ready. I'm ready to go right now. So, in 10 minutes, we certainly can be ready to read the instructions. Okay. All right, thank you. Please be seated. All right, at this time, the jurors have left the courtroom. Realistically, it'll be a little more than 10 minutes before they'll be ready to come back, in my experience. I'm ready to read the information and the charges. I told Ashley I'd be willing to do that, so she didn't have to do that. If the parties want to look at exactly what I'm going to read, I've just highlighted the portions of the information that I'll read, of course, omitting the citation to the specific statutes or the levels of offenses. It's only the parts that are in green. I'll set that at the bench. If anyone wants to look at it, you're welcome to. The instructions we have ready to go, so I think we're good with that. Did anybody have anything that they need to put on the record?
Your Honor, the state would be ready to proceed to opening statements today. We were anticipating calling our first witness tomorrow morning, but we can go out of order from what we anticipated and call Deputy Willis if the court would like us to proceed with calling our first witness today.
Frankly, I'd probably be very happy if we just got the initial, the opening statements completed today. If it seems like we had so much time that we should do that today, I think both of you know I like to keep plugging along, but probably it'll take me a half an hour typically or more to read the instructions and then give you the time to do your openings. We'll see where we are at that point. Perhaps we go forward with a witness, but I'd be very satisfied if we just had the openings done today probably also. So we'll just see where we are. Let's all take a break and let's really try to ourselves just be ready in about 10 minutes from now. All right, thank you. Thank you. Please be seated. All right, we're back on the record in State of Arizona versus Francis Mendoza-Keel, and at this time the jury is not present. The court will note the presence of both of the state's attorneys and case agent, as well as defense counsel and the defendant. And the jury, I understand, is ready, and they should be headed this way. We had a bit of a delay. One of the jurors indicated that right after being impaneled, indicated to the bailiff that they're allergic to scents and brought it to our attention about that. She may be in a mask when she returns to the courtroom. For all of us here, if anybody just wouldn't mind not using cologne or anything like that, if you think of it while you're doing your stuff, as much as we can accommodate the person, let's try to do that. But we had so many people in here for jury selection. I think it could be anything really. But I offered for Ernie to ask what we could do to accommodate her, and provided an N95 mask, and they moved the chairs apart a little bit while we were paused, and I haven't heard anything else about it, so there must not have been any other requests beyond that. So I think it's covered. So we should be ready to pick up where we've left off. Yeah, we can do that, but if those would probably have noise and other things. All right, the jury's here.
All right, the jury.
Thank you. Please be seated. All right, at this time, the record will reflect the jury is present with us at this time. At this time, ladies and gentlemen, I'm going to read the charging document and the charges specifically from that. And then I'm going to be reading the preliminary instructions. Why don't we go ahead and pass those out, and then I'll do both of those things at the same time, Ernie. So each of you is going to receive a copy of the preliminary instructions, which I'm going to be reading to you as close to word for word as I can here momentarily. If you'll take the copy that you receive, and under your seat, you should have a 3-ring binder. If you'll just take that set of instructions that you get and clip them into the 3-ring binder that you have. All right, is everybody clipped in? All right, I think so. At this time, I'm going to read the charges from the charging document. As to the first count, it reads, Count 1, aggravated assault. Francis Cruz Mendoza-Keel, on or about April 22nd, 2025, knowing or have reason to know that Colin Knight was a peace officer, knowingly did touch Colin Knight, a peace officer, with the intent to injure, insult, or provoke him. As to the second charge, it reads count 2, aggravated assault, Francis Cruz Mendoza-Keel, on or about April 22nd of 2025, knowing or having reason to know that Jeff Willis was a peace officer, knowingly did touch Jeff Willis, a peace officer, with the intent to injure, insult, or provoke him. As to the third charge, count 3, or it reads count 3, disorderly conduct, Francis Cruz Mendoza-Keel, on or about April 22, 2025, intentionally or knowingly did disturb the peace or quiet of a neighborhood, family, or person, to wit, Howard Leventhal, by engaging in fighting, violent, or seriously disruptive behavior. And as to the last charge, it reads count 4, assault, Francis Cruz Mendoza-Keel, on or about April 22nd, 2025, knowingly did touch Howard Leventhal with the intent to injure, insult, or provoke him. Now, as to each of these charges, the defendant has pled not guilty. The defendant is, by law, presumed to be innocent. At this time, I'll have you turn to the preliminary instructions that you've just received. Again, I'll just remind you, while I read the preliminary instructions, it's entirely your choice whether you choose to read along with me or if you just want to listen, that's fine also. That's totally up to you. I don't want you to feel compelled that you have to read. You can also just listen if that, just whichever works best for you and your opinion is entirely fine. So with that, I will begin. Jury service is an important part of our system of justice, with a long and distinguished tradition in American law. From the beginning, American law has viewed the jury system as an effective means of drawing on the collective wisdom, experience, and fact-finding abilities of persons such as yourselves. While it may be an occasional inconvenience or worse, jury service is an important responsibility for you, one which I am sure you will take seriously. Ladies and gentlemen, now that you've been sworn, I'll briefly tell you something about your duties as jurors and give you some instructions. At the end of this trial, I'll give you more detailed instructions, and those instructions will control your deliberations. It will be your duty to decide the facts. You must decide the facts only from the evidence produced in court. You must not speculate or guess about any fact. In deciding this case, you are not to be swayed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Race, color, religion, national ancestry, gender, or sexual orientation should not influence you. You will hear the evidence, decide the facts, and then apply the law I will give to you to those facts. That is how you will reach your verdict. In doing so, you must follow that law whether you agree with it or not. You must not take anything I may say or do during the trial as indicating any opinion about the facts. You and you alone are the judges of the facts. To assist you in considering the evidence that will be presented during the trial, I'll now tell you about the crimes with which the defendant is charged. The defendant is charged with aggravated assault, disorderly conduct, and assault. Crimes which require proof of the following. The crime of aggravated assault requires proof of the following. 1, the defendant committed an assault, and 2, the defendant knew or had reason to know that the person assaulted was a peace officer. The crime of assault requires proof that the defendant knowingly touched another person with the intent to injure, insult, or provoke that person. The crime of disorderly conduct requires proof that the defendant knowingly or intentionally disturbed the peace or quiet of a neighborhood, family, person, by engaging in fighting, violent, or seriously disruptive behavior. Intentionally or with intent to means with respect to a result or to conduct described by a statute defining an offense, that person's objective is to cause that result or to engage in that conduct. Knowingly means with respect to conduct or to a circumstance described by a statute defining an offense, that a person is aware or believes that the person's conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. Peace officer means any person vested by law with a duty to maintain public order and make arrests. The defendant has pled not guilty to these charges. The state must prove each element of the charged crime beyond a reasonable doubt. I will give you more details and definitions about the alleged crime in the final jury instructions. The state has charged the defendant with a crime. The charge is not evidence against the defendant. You must not think that the defendant is guilty just because the defendant has been charged with a crime. The defendant has pled not guilty. The defendant's plea of not guilty means the state must prove every part of the charge beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think that there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In deciding whether the defendant is guilty or not guilty, do not consider the possible punishment. A defendant in a criminal case has a constitutional right to not testify at trial, and the exercise of that right cannot be considered by the jury in determining whether a defendant is guilty or not guilty. If there is testimony in this case about what a defendant said to a law enforcement officer, you must not consider any such statements unless you determine beyond a reasonable doubt that the defendant made those statements voluntarily. A defendant's statement to a law enforcement officer was not voluntary if it was resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. You will decide what the facts are from the evidence presented here in court. That evidence will consist of testimony of witnesses, any documents and other things received into evidence as exhibits, and any evidence stipulated to by the parties or that you are instructed to consider. You may hear reference to exhibits that are not admitted and are not asked to be admitted. These exhibits are not admitted as evidence, but the information from them that is testified to by a witness is evidence that you may consider. You will decide the credibility of the witnesses and the weight to be given to any evidence presented in the case, whether it is direct evidence or circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is a physical exhibit or the testimony of a witness who saw, heard, touched, smelled, or otherwise actually perceived an event. Circumstantial evidence is the proof of a fact or facts from which the existence of another fact may be determined. The law makes no distinction between direct and circumstantial evidence. You must determine the weight to be given to all the evidence without regard to whether it is direct or circumstantial. During the trial, the lawyers are permitted to stipulate that certain evidence exists. This means both sides agree that evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. Admission of evidence in court is governed by rules of law. I will apply those rules and resolve any issues that arise during the trial concerning the admission of evidence. If an objection to a question is sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit is offered into evidence and an objection to it is sustained, you must not consider that exhibit as evidence. If testimony is ordered stricken from the record, you must not consider that testimony for any purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility of the witness or the weight you should give to any evidence that has been admitted. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for accuracy and truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in light of reason, common sense, and experience. The rule of exclusion of witnesses is in effect and will be observed by all witnesses until the trial is over and a result announced. This means that all witnesses will remain outside the courtroom during the entire trial except when one is called to the witness stand. They will wait in the areas directed by the bailiff unless other arrangements have been made with the attorney who has called them. The rule also forbids witnesses from telling anyone but the lawyers what they will testify about or what they have testified to. If witnesses do talk to the lawyers about their testimony, other witnesses and jurors should avoid being present or overhearing. The lawyers are directed to inform all their witnesses of these rules and to remind them of their obligations from time to time as may be necessary. The parties and their lawyers should keep a careful lookout to prevent any potential witness from remaining in the courtroom if they accidentally enter. From time to time during the trial, it may become necessary for me to talk with the attorneys out of the hearing of the jury, either by having a conference at the bench when the jury is present in the courtroom, or by calling a recess. Please understand that while you are waiting, we are working. The purpose of these conferences is not to keep relevant information from you, but to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. We will, of course, do what we can to keep the number and length of these conferences to a minimum. I may not always grant an attorney's request for a conference. Do not consider my granting or denying a request for a conference as any indication of my opinion of the case or what your verdict should be. Please do not be concerned with what we are discussing at any bench conference we may have. Please respect the privacy of those participating in the bench conference in order to maintain the fairness of the trial. As I mentioned earlier, it is your job to decide from the evidence what the facts are. Here are 6 rules on what is and what is not evidence. 1. Evidence to be considered. You must determine the facts only from the testimony of witnesses and from exhibits admitted in evidence. Anything you may see or hear when the court is not in session, even if what you see or hear is done or said by one of the parties or by one of the witnesses, is not evidence and must not be considered by you. If you should hear or see anything pertaining to the case outside the courtroom, or if anyone should attempt to speak to you about this case outside the courtroom, please report it to me as soon as you can. 2. Lawyer statements. Statements or arguments made by the lawyers in the case are not evidence. Their purpose is to help you understand the evidence and law. 3. Questions to a witness. A question is not evidence. A question can only be used to give meaning to a witness's answer. 4. Objections to questions. If a lawyer objects to a question and I do not allow the witness to answer, you must not try to guess what the answer might have been. You must also not try to guess the reason why the lawyer objected in the first place. Rejected evidence, number 5. At times during the trial, evidence may be offered that I do not admit as evidence. When evidence is not admitted, you must not consider it for any purpose. 6. Stricken evidence. At times, I may order some evidence to be stricken from the record. Then it is no longer evidence, and you must not consider it for any purpose. At the end of the trial, you will have to make your decision based on what you recall of the evidence. You will not be given a written transcript of any testimony. You should pay close attention to the testimony as it is given. You have been provided with notepads and pens. The court encourages you to take notes during the trial if you wish to do so. Do not let note-taking distract you so that you miss hearing or seeing other testimony. You may use your notes during your deliberations at the end of the trial. Until then, keep your notes to yourself. During recesses in the trial, you may leave your notes on your seat. Your notes are confidential, and my bailiff will guard them. No one will be allowed to read your notes. Whether you take notes or not, you should rely upon your own memory of what was said and not be overly influenced by the notes of other jurors. After you have rendered your verdict, the bailiff will collect your notes and destroy them. Do not be influenced at all by my taking notes at times. What I write down may have nothing to do with what you will be concerned with at this trial. I'm now going to say a few words about your conduct as jurors. I'm going to give you some do's and don'ts, mostly don'ts, which I will call the admonition. Do wear your juror badge at all times in and around the courthouse so everyone will know that you are on a jury. Each of you has gained knowledge and information from the experiences you have had prior to this trial. Once this trial has begun, you are to determine the facts of this case only from the evidence that is presented in this courtroom. Arizona law prohibits a juror from receiving evidence not properly admitted at trial. Therefore, do not do any research or make any investigation about the case on your own. Do not view or visit the locations where the events of the case took place. Do not consult any source such as a newspaper, a dictionary, a reference manual, television, radio, or the internet for information. If you have a question or need additional information, submit your request in writing and I will discuss it with the attorneys. Do not talk to anyone about the case or about anyone who has anything to do with it. And do not let anyone talk to you about those matters until the trial has ended and you have been discharged as jurors. This prohibition about not discussing the case includes using email, Facebook, Snapchat, TikTok, Twitter, MySpace, instant messaging, BlackBerry messaging, iPhones, Google, Yahoo, any internet search engine, any artificial intelligence search, or any other form of electronic communication for any purpose whatsoever, if it relates in any way to this case. This includes, but is not limited to, blogging about the case or your experience as a juror on this case, discussing the evidence, the lawyers, the parties, the court, your deliberations, your reactions to testimony or exhibits, or any aspect of the case or your courtroom experience with anyone whatsoever until the trial has ended and you have been discharged as jurors. Until then, you may tell people you are on a jury and you may tell them the estimated schedule for the trial. But do not tell them anything else except to say that you cannot talk about the trial until it is over. One reason for these prohibitions is because the trial process works by each side knowing exactly what evidence is being considered by you and what law you are applying to the facts you find. As I previously told you, the only evidence you are to consider in this matter is that which is introduced in the courtroom. The law that you are to apply is the law that I give you in the final instructions. This prohibits you from consulting any outside source. If you have cell phones, laptops, or other communication devices, please turn them off and do not turn them on while you're in the courtroom. You may use them only during breaks, so long as you do not use them to communicate about any matter having to do with the case. You are not permitted to take notes with laptops, Blackberries, tape recorders, or any other electronic device. You are only permitted to take notes on the notepad provided by the court. Devices that can take pictures are prohibited and may not be used for any purpose. It is your duty not to speak with or permit yourselves to be addressed by any person on any subject connected with the trial. If someone should try to talk to you about the case, stop him or her or walk away. If you should overhear others talking about the case, stop them or walk away. If anything like this does happen, please report it to me or any member of my staff. And then I have Mary, my judicial assistant's phone number, directly to the office on the other side of the door there as 928-679-7575 as soon as you can. To avoid even the appearance of improper conduct, do not talk to any of the parties, the lawyers, the witnesses, or media representatives about anything until the case is over, even if your conversation with them has nothing to do with the case. For example, you might pass an attorney in the hall and ask what good restaurants there are downtown, and somebody from a distance may think you are talking about the case. So again, please avoid even the appearance of improper conduct. The lawyers and parties have been given the same instruction about not speaking with you jurors, so do not think that they're being unfriendly to you. When you go home tonight and family and friends ask what the case is about, remember you cannot speak with them about the case. All you can tell them is that you are on a jury, the estimated schedule for the trial, and that you cannot talk about the case until it is over. In a civil case, the jurors are permitted to discuss the evidence during the trial while the trial progresses. In a criminal case such as this, however, the jurors are not permitted to discuss the evidence until all the evidence has been presented and the jurors have been retired to deliberate on their verdict. You may not discuss the evidence among yourselves until you retire to deliberate on your verdict. Therefore, during breaks and recesses, whether you are assembled in the jury room or not, you shall not discuss any aspect of the case with each other until the case is submitted to you for your deliberations at the end of the trial. Again, if you have a question or need additional information, submit your request in writing and I'll discuss it with the attorneys. During the trial, you are not to engage in any conduct that impairs or interferes with your ability to hear and understand the court proceedings. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all of the evidence, the closing arguments, and the rest of the instructions that I will give you on the law. Keep an open mind during the trial. Form your final opinions only after you have had an opportunity to discuss the case with each other in the jury room at the end of the trial. Please advise me in writing immediately if you believe that any juror has violated any provision of this admonition. Before each recess, I will not repeat the entire admonition that I've just given to you. I will probably refer to it saying, please remember the admission or something like that. However, even if I forget to make any reference to it, remember that the admonition applies at all times during the trial. There may be or may not be news coverage of the trial. What the news media covers is up to them. If there is media coverage, you must avoid it during the trial. If you do encounter something about this case in the news media during the trial, and you're end your exposure to it immediately and report it to me as soon as you can. If there are cameras in the courtroom during the trial, do not be concerned about them. Court rules require that the proceedings be photographed or televised in such a way that no juror can be recognized. If at any time during the trial you have difficulty hearing or seeing something that you should be hearing or seeing, or if you get into personal distress for any reason, please raise your hand and let me know. If you have any questions about parking, restaurants, or other matters relating to jury service, feel free to ask one of the court staff. But remember that the admonition applies to court staff as it does to everyone else. So do not try to discuss the case with court staff. If you have a question about the case for a witness or for me, write it down, but do not sign it. Hand the question to the bailiff. If your question is for a witness who is about to leave the witness stand, please signal the bailiff or me before the witness leaves the stand. The lawyers and I will discuss the question. The rules of evidence or other rules of law may prevent some questions from being asked. If the rules permit the question and the answer is available, an answer will be given at the earliest opportunity. When we do not ask a question, it is no reflection on the person submitting it. You should attach no significance to the failure to ask a question. I will apply the same legal standards to your questions as I do to the questions asked by the lawyers. If a particular question is not asked, please do not discuss why or what the answer might have been. The trial is expected to last through Thursday, March 19th. We will all do our best to move the case along, but delays frequently occur. These won't be anyone's fault, so don't hold them against the parties. Delays usually occur because the attorneys and I often need to resolve certain legal matters before these matters may be presented to you in court, or because I'm busy with matters in other cases. The usual hours of trial will be from 9 o'clock a.m. to 5 o'clock p.m. We'll take short recesses about every mid-morning and mid-afternoon, and occasionally stretch breaks in place. We'll recess at 5 o'clock p.m. and begin again at 9 o'clock a.m. Unless a different starting time is announced prior to recessing for the evening, you may assume a starting time of 9:00 a.m. for the next day. At the beginning of the day, please assemble in the jury room for this division. Please do not come back into the courtroom until you are called by the bailiff. Criminal trials generally proceed in the following order. First, the prosecuting attorney will make an opening statement giving a preview of the case. The defendant's attorney may make an opening statement outlining the defense case immediately after the prosecutor's statement, or it may be postponed until after the state's case has been presented. What is said in opening statements is not evidence, nor is it argument. The purpose of an opening statement is to help you prepare for anticipated evidence. Second, the state will present its evidence. After the state finishes the presentation of its evidence, the defendant may present evidence. If the defendant does produce evidence, the state may present additional or rebuttal evidence. With each witness, there is a direct examination, a cross-examination by the opposing side, and finally, redirect examination. I should note that you get to ask questions of each witness at that point as well if you have questions. And this usually ends the testimony of that witness. Third, after all the evidence is in, I will read and give you copies of the final instructions. The rules of law you must follow in reaching your verdict. Fourth, the attorneys will make closing arguments to tell you what they think the evidence shows and how they think you should decide the case. The state has the right to open and close the argument since the state has the burden of proof. Just as in opening statements, what is said in closing arguments is not evidence. Fifth, you will deliberate in the jury room about the evidence and rules of law in an effort to reach the verdicts. If you unanimously agree upon the verdicts, they will be read in court with you and the parties present. Sixth, in some circumstances, it may be necessary for you to make additional findings. If this is the case, I will give you further instruction at that time. Finally, you will be discharged and released from the admonition. The law provides for a jury of 8 persons in a case such as this. We have more than 8 jurors so that if a juror becomes ill or has a personal emergency, the trial can continue without that juror. At the end of the case, alternate jurors will be determined by lot in a drawing held in open court. Please do not be concerned with who may or may not be chosen as an alternate at the end of the case. The rules of law that I have just shared with you in the past few minutes are preliminary only. At the end of the case, I will read to you and give you a copy of the final instructions of law. In deciding the case, you must be guided by the final instructions. At this time, did the lawyers have any additions or corrections to the instructions as read?
I think there was a brief typo, but I think it's something we can fix for the final instructions. I don't have any additions or corrections at this time.
All right, thank you.
I do not have any additions or corrections at this time.
All right, thank you. And from the defense?
Nothing from us, Your Honor.
All right. With that, is the state ready to proceed with its opening statement?
We are, Your Honor.
And do you intend to use the overhead?
I do.
All right, let me turn that over to you. Are you ready for it?
I believe so.
Okay. All right, whenever the state's ready to proceed, and you're welcome to move things around however you like.
This is a case about assault. We're going to hear about assault. The defendant's name was Howard Leventhal. He was assaulted by me.
Mr. Kent, I'm sorry, could you just make sure that your microphone's on? And we'll thank the clerk for catching that. Thank you.
You're going to hear about how the defendant Francis Mendoza-Keel assaulted his landlord, Howard Leventhal. Mr. Leventhal called the police, and police officers responded to the scene. You're going to hear about how the officers, Coconino County Sheriff's officers, Deputy Willis and Corporal Knight, conducted an investigation. They spoke to Mr. Leventhal, and then they spoke to the defendant, Mr. Mendoza-Keel. What happened when the officers arrived after speaking to Mr. Mendoza-Keel was an assault on the officers. This is a screenshot or a freezed frame of Deputy Willis's body camera during the assault when the defendant fought, threw punches, grappled, attempted to put the officers in a headlock, and threw a running, jumping punch at Corporal Knight. It's hard to see, it might be difficult to see what's happening in this frame because it is cut off. What you'll see here is the defendant, his legs in the air as he throws a punch at Corporal Knight's head. In addition, you're going to see in this case body camera, the fuller videos from Deputy Willis and from Corporal Knight. You're going to hear their testimony about what happened and the context that surrounds that body camera. You're going to hear testimony from the landlord, Howard Leventhal, who was first assaulted by the defendant. This case it's not complex. You're only going to hear from 3 witnesses in the state's case and view a couple minutes of body camera and a frame such as this. There's not going to be DNA evidence, fingerprints, things of that nature. You're also going to hear that when the officers arrived to investigate, they spoke to the defendant, Mr. Mendoza-Keel. They asked him for his side of the story, what had happened with the assault on the landlord. During that conversation, the defendant admitted that he did hit the landlord. He admitted to hitting him in the head and knocking his glasses off. Shortly after that, the officers told Mr. Mendoza-Keel that he was going to be placed under arrest. His response was not compliance. His response was saying no and immediately starting to fight the officers, throwing punches, grabbing onto them, trying to get them into headlocks, and fighting them so intensely that he eventually had to be tased, taken to the ground to gain compliance and for the episode to end. I'm going to show you about a minute clip of body camera of the most relevant part of this. That is from Corporal Knight's body camera. If it will play. One moment. Oh, why isn't that one going? The first 30 seconds are going to be silent, and you'll hear more about during the trial about why that is. Hit the lights. That was just one clip that you're going to see during the trial. And you're going to hear, you'll be able to see that again, and you're going to hear testimony giving context to what was happening there. But this is just a preview of what the state's evidence is going to show. This is an opening statement. It's not my chance to argue to you about how the facts fit the law of what the defendant is charged with. That will come at the end of this trial during my closing statement. What I want you to do in this case, and it's in the instructions, is to use your reason, common sense, and experience from the everyday world on applying the facts to the law in this case. The courtroom is not a magical place where the standards are different, that just because if you believe something is true in your everyday life, if that is the same belief you have underneath the law and the directions, the instructions you have here, you should apply your thoughts in the same way you would in a courtroom as you would in everyday life. At the end of this case, after you've heard the testimony and seen the exhibits from the state, I'm going to come back up here and I'm going to ask you to find the defendant guilty on all counts. Thank you.
All right, thank you, Mr. Hartmann-Schorn. And were you going to use the overhead? All right,
Your Honor.
Just tell me when you're ready for it.
Thank you so much. I'm going to be using this as well.
Are you ready?
I'm ready, Your Honor. Good afternoon, everyone. Francis sits here in front of you today because he tried to stand up for his rights. On April 22nd of last year, Francis was at home. Francis lived on a small rural property where he worked in exchange for rent. This property was owned by Howard Leventhal, the alleged victim in this case. The day of the events that we are here about, Francis was working on that property as part of that agreement he had with Howard. As you will hear, earlier that same day, Howard and Francis had an argument over their arrangement. Howard felt that Francis wasn't living up to his end of the bargain. Francis, as you will hear, felt differently, and they argued over this. At issue were the exact terms of their handshake rent agreement. However, Francis did not assault Howard during this disagreement. Howard drove away, and Francis went back to work. He did not try to hide or flee the scene to avoid the deputies that would come, He did not try to hide or flee the scene. An SUV from the Coconino County Sheriff's Department rolled up to where Francis was working. Two officers got out of their vehicle and began asking Francis about questions about the assault. That's what we just saw here. Francis was confused. As far as he can tell, he's honoring the agreement that he struck with Howard. He did not assault Howard. He made no attempt to run from the deputies or to avoid them once he was confronted. You'll see that Francis, confused as to why he's being questioned about an assault he did not commit, calmly declines to answer the questions that the officers are asking. That's what we just saw, that standoff between the officers and Francis as he's not answering the questions they're asking him. Francis calmly declines to answer any of the questions that are being brought to him. Francis is actually just following the same legal advice that any good criminal defense attorney would give their client. Don't make any statements about criminal allegations to law enforcement without an attorney present. It's such routine legal advice that I'm sure some of you have heard the same. I'm guessing that everyone's heard the Miranda advisement that you have the right to remain silent once you're placed under arrest. Under the law in Arizona, you actually have to provide law enforcement with your name if they ask you for it, and you must provide it truthfully. But from there on out, it's your right not to make any more statements. This limitation is in fact there precisely to defend your right to protect against self-incrimination. At this point, things escalate. Officer Jeffrey Willis moves to arrest Francis, as we just saw. after he's refusing to answer questions. Francis, still confused as to why he's being arrested, why he's being confronted by law enforcement, begins to resist the officer's attempt to place him under arrest. This proceeds, as we saw, to Francis being in a physical altercation with both Officer Willis and the other arresting officer, Corporal Knight. And he's the officer from whose perspective we just saw that. Now, officers are allowed to use force when they effectuate an arrest. However, Arizona law provides that a person being arrested can act in self-defense if the force being used against them exceeds that allowed by law. Now, use of force in Arizona is set out very clearly that it's justified if 3 requirements are met. And I have those 3 requirements up here on the screen for you. First, the officer must reasonably believe that the force used is necessary to effectuate the arrest. Second, the officer must make known the purpose of the arrest or the detention to the person who's being arrested. Finally, a reasonable officer must believe the arrest to be lawful. All 3 of these things need to be present at the same time for that arrest to be to support essentially the use of force for that arrest. Now, if one of these requirements is not met, then under Arizona law, it becomes permissible for someone to exercise self-defense in order to protect against what is an unlawful arrest. Really at issue in this case is the first requirement and the third requirement. Officer Willis did announce to Francis that he was under arrest, as we just heard, so that second requirement is clearly met. What I will be asking you to evaluate at the end of this trial, when you go back into the jury room to deliberate, is if the first and third requirements were met by Officer Willis and Corporal Knight. By the end of this trial, you will see that they were not. There was no assault on Howard Leventhal, and in turn no reason to lawfully arrest Francis, let alone use force to do so. As a result, Francis acted in self-defense, which is allowed, as we just discussed, under the law, if law enforcement does not meet all 3 of the requirements that we're looking at. It is our position only one of those requirements was met, and you will see that over the course of this trial. Self-defense is a justification defense, which is an important distinction and an important concept for you as members of the jury. Just as the burden is on the state as to the crimes that Francis is charged with to prove those beyond a reasonable doubt to you as a jury, they also bear the burden to prove beyond a reasonable doubt that Francis was not justified in using self-defense. So let's just revisit that. The burden is not on Francis. The burden is not on me to prove that he was justified in using self-defense. The state has to prove that he was not justified. If the state does not convince you beyond a reasonable doubt that Francis was not justified in using self-defense, then you must find Francis not guilty on those charges. Furthermore, if the state does not convince you beyond a reasonable doubt that Francis assaulted Howard, you must find him not guilty on that charge as well. Beyond a reasonable doubt. That is a very high standard, but it's a high standard for a good reason, to protect innocent people. So what exactly does beyond a reasonable doubt mean? This means that the prosecution must convince you, the members of the jury, that there is no other reasonable explanation that can come from the evidence presented at trial. It also means that at the end of the trial, if you have any reasonable belief that Francis did not assault Howard and was justified in using self-defense when he was being arrested, you must find him not guilty on those charges. You will see by the end of this trial that the state cannot prove their case beyond a reasonable doubt, and they cannot prove beyond a reasonable doubt that Francis was not justified in his actions. And when you do not feel firmly convinced, then you must find Francis not guilty. Thank you.
All right, thank you. At this time, we're going to take our recess for the evening, and we'll begin with the presentation of witnesses tomorrow. So you get the jury's going to be excused a little bit early tonight. We will see everyone back tomorrow. If you'll report to the courthouse just a little bit before 9 o'clock, we'll do everything in our power to be ready to start with the presentation of the state's case through its witnesses right at 9 o'clock. If for some reason that doesn't happen right at 9 o'clock, I apologize in advance, but that's every intention that the court has to do that. So have a good night. I'll remind you of the admonition that we just read together moments ago. That applies throughout the course of the trial. It applies tonight. As people, you go home, everybody's going to get asked, what's it about? You can't tell anybody what it's about. You can tell them that you're on a trial. You can tell them how long that trial is expected to last. And when it's all over, deliberations have occurred, and you've been excused from service, at that point you can tell them all about it if you want to or not. But right now, the admonition applies. So just keep that in mind overnight and anytime we take any breaks during the course of the trial or for the next couple of days. And we'll see you back tomorrow morning. All right, thank you. Please be seated. At this time, unless anyone has anything to address, I think that we're ready to break for the evening as well.
The state does, Your Honor.
Go ahead.
Your Honor, it's come to my attention from speaking to defense counsel. They plan to admit a larger portion of the body camera after Mr. Mendoza-Keel is detained on the ground in this video and after the fight is over. I think in the next 30 seconds to a minute after the state stopped its video that the court just saw, Mr. Mendoza-Keel is detained, put in handcuffs, and says things to the effect of, "This was self-defense, you assaulted me," things like that. My understanding is the defense is moving to admit that portion of the body camera. The state is going to be objecting to any admission, to the admission of any body camera after what was shown today in court on the grounds that the statements from the defendant at that time are hearsay if offered by the defense. And it's just not relevant. The assault is what we're here to talk about, and it's over at that point. Defendant's statement, even 30 seconds later, that him giving his legal analysis that this was self-defense or you assaulted me, I just don't think are admissible statements. If the defendant wants to testify and say how he felt in the moment, that's one thing. But without that, or even with that, the state will be objecting to admission of those further portions of the body camera.
All right, Mr. Hartman-Strong, can you address that at this time?
Absolutely, Your Honor. We believe, and I'm sorry, I had the rule yesterday. Yes, the rule of completeness, Arizona Rule of Evidence 106, governs this issue. I believe that we have a portion of this recording coming into the trial. I believe there's proper foundation for it. Through Officer, I believe that is, Corporal Knight's footage that we're talking about specifically. And that when, as the state said, Mr. Mendoza-Keel is brought to the ground, instantly he's talking. There's no delay, and he's saying exactly what is the basis of his defense. And so I think it's both. I think the rule of completeness governs that this should come in because the state has selectively edited it to stop at the point where there's anything beneficial for the defendant, which I get their strategy there, but I think the rule of completeness governs against that. Additionally, I think just in terms of relevancy concerns, it's extremely relevant. He lays out the defense I just laid out in my opening statement. So I think I can bring in the rest of the clip, even just having the Corporal Knight lay foundation if I need to. So Your Honor, it would just be our position that we're entitled to have that remaining. The video is actually about 10 minutes long, so I'm just asking for the next 30 seconds. So we think we're entitled to that next 30 seconds, or at the very least that I'm going to be able to introduce it with Colin Knight, or Deputy Knight, Laying Foundation. Sorry, Corporal Knight, excuse me.
What about the argument that the statements is, I haven't seen this, but so I'm just basing on what you're all telling me, but what about the argument that it's the statements by the defendant in those 30 seconds are just self-serving hearsaying being offered for the truth of the matter asserted in those statements?
Your Honor, we think it's his instant impression of what's going on, and I think it's relevant because it gives us a mindset into what he was thinking at the moment. Also, I mean, it's the comments of the party opponent, so it's, the defendant here is making the statement, so it's my understanding that they can come in under that.
All right. Anything further from the state?
Yes, Your Honor. So as to the rule of completeness argument, I don't think that applies here. The state isn't admitting this body camera for the defendant's statements. I think he makes a couple brief statements, something like, no, I'm not under arrest. Yeah, I like it. And I'm good once they have him on the ground. That's about it. I think those are defendant statements, which the state is introducing as a party opponent statement. But this idea that there's, some longer conversation or some selectively edited clip of the defendant's statements that the need to be admitted to provide context is just not the case in this. And we can come back tomorrow and I can brief this a little more fully. I'm happy to show I think it would make sense to show these 30 or more seconds to the court so it can see what we're talking about here. But I just don't think the rule of completeness is about completion of a person's statement. I get the defense wants to complete what happened after he's on the ground and he starts saying other things, but that's really, it's not completing any statements. And there's no incomplete statement or that is taken out of context that we need to provide context to. I also just renew my statement that even if the rule of completeness did allow for this, the statements are still hearsay, or self-serving hearsay from the defendant, and they're really effectively his legal conclusion that this was self-defense and you attacked me. So for all those reasons, the state will be objecting.
All right, thank you. We'll address this at 8:30 tomorrow. Each of you are welcome to brief the issue. I'd welcome the briefing if there's any specific cases that you want me to look at that you think are supportive of your respective positions. Provide those to the court. I'd like to start addressing the issue tomorrow with the video itself so that I actually know what we're talking about, since I've not seen I haven't seen this. This was the first time I saw the one portion of it. So the court will have a full perspective of the exhibit itself, and then we'll argue it further based upon whatever your research turns up over the course of the evening. Anything further for tonight?
I had one or two things about the instructions, but I'll save that for when we go over the final instructions.
Okay, what was it in relation to? I was curious.
Page 3, there was just missing an or, I think, and it said exits instead of exists on page 9.
Okay.
So
well, they're bad.
Small issues.
And it doesn't sound like those are driving any major concerns.
No.
The final instructions don't build on these at all. So those mistakes, if they're in there, they won't be part of the final instructions. So there won't be any carryover. Anything further?
No, Your Honor.
Nothing plus, Your Honor.
I'll see you back in the morning.